All right. Let me hold on. The live stream's still coming up. Okay, so we are back streaming on live on YouTube. Um, so this is resuming the state of Georgia versus Kelly Stillwell case, and Miss Grimes, her camera and audio are working now. We're going to resume. She has been called by the defense to testify. So, Mr. Rogers, I will turn it over to you. And do you want to swear her in?
That's fine.
Okay.
Would you please raise your right hand?
Okay.
And, and do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You can put your hand down. Can you please state your name for the record?
Alicia Nicole Grimes,
And what state do you live in?
Kentucky.
And do you know Kelly Stillwell?
I do.
Is that the name you know the defendant by?
Yes.
Do you ever refer to the defendant by any other names?
Star Kelly, yes.
And are you aware that the defendant is charged regarding the possession of a vehicle?
I am.
Do you know what do you know about how the defendant came to be in possession of that vehicle?
On January the 31st, earlier that morning, Kelly had called me and asked me, could I take her to get the car from Starla? This is in a small town going towards Bowling Green, Kentucky. So we was able to get together that evening around 6:30. So it took us about a couple hours to get there. And once we had gotten there, we had pulled up into the driveway, and Kelly got out of the car and went into Miss Starla's home. The porch light was on. They came back out. In the process, Starla had handed Kelly the keys to the vehicle. She proceeded to go to the vehicle. The son had came up to the car with a battery charger because he said one of the cells.
Let me stop you right there. Hang on one second. You said the son?
Yes, her son,
Whose son? You say her son. Whose son are you referring
Starla's son,
to? Okay. And you were saying it
came up
came.
to the car. I'm sorry.
Oh, go ahead. No, you were saying with the battery
Came up
charge.
to the car with the battery charger and said the cell was dead. One of the cells was dead in the battery, that it may possibly need a to be jumped. But the car went ahead and started on up. And after she started the car. I mean, I backed up. She backed, because she had to lead us back out because I didn't know the directions. And we ended up just leaving, and that was it. And we got on 65, and I come on home because I had to work the next one and be up at 4 in the morning. And that was the extent of it.
And just so I'm clear, I want to make sure that everybody's clear about what you're saying. Are you saying that you actually saw Starla hand the
Yes, yes, she did hand the key fob to her
keys
on the porch.
to,
Yes.
and the son, just so I'm clear, was there to help get the car started if it needed to be started?
Yeah, yes, because there was supposedly a cell that was dead in the battery.
No further questions at this point.
All right. And Miss Thomas, any cross?
Yes, Your Honor. Ms. Grimes, can you hear me?
I can.
Okay, great. I'm the prosecutor in this case. I've got a couple of questions for you.
Yes.
How do you know the victim in this case?
Me and Kelly, we've known each other since been about, I mean, all of our lives really, because we both from Stevensburg, Kentucky originally.
Okay, you're referring to the defendant. That's Kelly, correct?
Correct. Yes.
I'm talking about the victim, the person who actually owns.
Oh, now Starla, I had never ever met. I own another home here in the town that I live in, and Kelly lives in it. And I
Okay.
know that she did supposedly came up and help Kelly work on the floors and
Wait a
with the
minute. I'm gonna
water
stop you
lines.
right here. Hold on one second, ma'am. You don't know for sure if or how Starla knows this gentleman, correct?
Except for the fact that she came up. She is friends with Kelly's sister, Lynn. She is friends with her personally. Kelly
But
met
you
her
don't-
through. I'm sorry.
Go ahead.
Kelly met Starla through Lynn, which Starla came up and worked on the home that I own.
But you don't know if Starla ever gave Kelly permission to take anything, particularly a car, do you?
Only thing that I know is the conversations they was having on the phone while we was riding down to go and get the car, because she did call Starla and let her know that we was on our way. So with the conversation there, but it wasn't on speaker, so I'm not going to lie about that because it was not.
So you don't know.
No, only thing I know is she just called me and said that Starla said she could use the car.
And she was talking, when she said she could use the car, she wasn't talking about him, correct?
She was talking about Kelly could use the car, yes.
But you didn't hear her say that.
No.
And you don't know if Kelly bought the car. You don't know what happened to the car after that, do you?
After we picked it up? After we picked up the car or prior to that?
Yes. After the car got missing.
No, after we left, when we went out the driveway, I followed Kelly to 65 and I went on home.
Okay. Yeah, that's all I have.
All right. And Mr. Rogers, any redirect?
Just briefly.
Okay.
So I just want to make sure I'm clear on I understand you don't know anything that happened after you were there, but as it relates to what you saw.
I mean, no, because like
Are
I
you
said,
saying,
go ahead.
no, I was asking, did you see what happened at the location where the vehicle was picked up?
I mean, what do you mean? Did I see what?
As far as you mentioned Starla giving the keys, are you saying you personally witnessed that?
Oh, yeah, yes, because she handed them to her on the porch. And of course, Kelly got in the car and the car started. The son didn't have to jump it. So I had to back up to let Kelly get out because the Taurus was in front of me.
No further questions.
Okay. All right. And let me ask, Mr. Rogers, any other witnesses today?
No, sir, just argument.
Okay. And is everyone okay with us releasing Miss Grimes?
Yes, Your Honor.
Okay. So Miss Grimes, thank you very much for joining us. Is that okay, Mr. Rogers?
Yes, sir. No problem.
Okay.
No objection.
Gotcha. All right. So Miss Grimes, thank you for joining us today. And so I'll put you back in the waiting room, but you can go ahead and log off.
Okay, so I don't need to, I can go ahead and get out the system, period.
Yes, ma'am. That'll be great.
Okay.
Thank you. Okay.
All right, thank you.
Uh-huh. Okay. And let's see. So Miss Thomas, do you want to reserve closing?
Yes, Your Honor.
All right. And Mr. Rogers, we'll hear from you.
Thank you. Judge, a couple of things I want to say about this case. I guess the first thing we need to keep in mind, I think, is that at the end of the day, it's still theft by receiving. There's a different, I guess, clause or phrase attached to the end of it, but it's still a theft by receiving case. And just for clarity, I actually pulled the citations on it. So there's a case in Nelson v. State, 357, Georgia App 515. And I'm really just offering this because it sets out that 1688 still has that theft by receiving requirement of knowledge, knowing that the item is stolen, or one should know that the item is stolen. And in this case, there's been no basis alleged to say that the defendant should know that the vehicle is stolen or anything of that nature. There's no, attempt to conceal the vehicle's identity. There's no attempt, as far as I can tell, to evade police. There's nothing obvious about the vehicle that would call into question, the legitimacy of the vehicle or anything like that. There's been just no basis off to say that person knows or should know that the vehicle was stolen. Additionally, for first, I would ask the court to dismiss that charge in total for lack of probable cause. But I guess I don't want to call it an alternative argument, but I will point out that there's been no testimony about the value of the item, as far as the value of the item that was stolen, or testimony about the well, I guess there was a mention of the model, but that was it. No testimony about the year, the mileage, anything about the condition of the vehicle that would support a finding that is over a felony threshold. So an alternative, I would ask that the court would reduce the charge to a misdemeanor, if not an outright dismissal. Thank you.
Ms. Thomas?
Your Honor, there's a presumption that a motor vehicle in and of itself is in excess of $500. In this particular case, we have an officer who responded to a stolen vehicle hit. The vehicle was not removed from the system from Kentucky. The officer actually, and somewhat unusual in my experience, was able to speak directly to the victim, who indicated at the time that she had not given this man permission to drive her car. She didn't give him permission to take the car from Kentucky. Your Honor, that is sufficient in and of itself to establish probable cause that he had the victim's vehicle without her permission and did not have an intent to return the car to her. Particularly in light of the defense witness, Ashley, Your Honor, who is contending that these people know each other. Even though the victim is saying that as of when she filed that report, she did not. So state would contend at this point in time, Your Honor, the sufficient probable cause has been established based on the testimony of the officer that the case can be bound over to the Superior Court of Clayton County.
Okay.
Yeah.
Let me. Oh, I'm sorry. Go ahead.
Judge, I don't normally do this, but the part about there being a presumption about the value.
Well, I was about to ask kind of the same question here. So, Ms. Thomas, you said there is a presumption if it is an automobile that it would be over 500. So I got two questions on that. The first is that presumption codified, or is that in case law or anything?
Your Honor, let me look.
Or are we just saying common sense?
Common sense more so than anything, Your Honor, but I actually have seen it. Let me look at it.
So I was looking at the code section because I can't recall. It doesn't come up very often. But also, aren't we looking at a $1,500
exactly
amount instead of a $500?
Yes, Your Honor, we are.
So if we're talking about common sense, 500, I can say, well, the salvage value on a car is probably getting around there, but 1,500 is a little different, and I don't know what year. I know Taurus, but I don't know what year, mileage, anything else. So I don't know that I can assume here without evidence that it is over the 1,500 mark in terms of value.
Your Honor, I just got the report.
Judge,
we've closed evidence, officer. We're done with that part.
Okay.
So, and you both finished closing, right? Sorry, I just had a moment where I was like, I did let everybody finish, right? There's obviously a discrepancy here between what the witness says and what the victim has said. I know there's some type of relationship here, personal relationship, obviously, between the defendant and the witness who testified today. I know that the victim informed the officer that she did not know the defendant by name and did not give anyone permission to use that car. And I find that to be sort of the more credible evidence here. I do think there is probable cause for a theft by receiving charge. I do think that needs to be amended to a misdemeanor based on no probable cause that there was a value of greater than 1,500 here that I can find. So I think it does need to be bound over to state court as a misdemeanor. And I think that's what I need to that'll be my order today. So I'm going to bind this over to state court as a misdemeanor, theft by receiving. Okay. And Okay, so Officer St. Jean, if you don't have any other, or Sergeant St. Jean, if you don't have any other cases today, you can be excused. And deputies, that will take care of everything on Mr. Stillwell's case today, and so he can be taken back. Thank you.
All right, thank you.
All right.
Excuse me, Judge Parker.
Yes.
I have concluded my business with the court for the day. May I please be excused?
Yes. Thank you. Good to see you.
Thank you. Good to see you.
Stillwell.
Yeah. Your Honor.
Yes.
Hey, I was gonna see if we could go through with Mason, inmate Mason, because he has court upstairs at 2 o'clock.
That's good with me, Miss Thomas. Would we be ready to go on Mason?
Well, Judge, it's not here. I just needed to talk to him. I just haven't. I can just jump in and talk to him.
Oh, okay. All right. Let me transfer you into a breakout room while I kind of get reset here.
Can someone let Ms. Grimes know that she can go? She still
It
sits.
looks
Let's see. Oh, I think that's her other device. She was logged in on 2 devices here. I'll put that in the waiting room. There we go. Okay. Yeah, so Mr. Rogers and deputies at the jail, you guys can transfer into breakout room number 1.
Your Honor, did Mr. Rogers go into a breakout room?
Yeah, with the jail. Yeah.
Okay, I thought he wanted to speak to me. Okay.
Ms. Thomas, what would be the next hearing that you want to get started?
Trevor Booker, Your Honor.
Booker, okay.
That would be Officer Jackson's case.
Okay. So we'll get kind of ready here for Trayvon Booker, and then when Mr. Rogers gets back, we'll get started there. I'm going to take a 2 or 3 minute break here, and I'll be back in just a little bit.
And Judge, that's a bond waiver on Mr. Mason.
Mason will be a bond waiver.
Yes, sir.
Okay. All right.
Officer Alexander, you're excused. Detective Alexander, you're excused.
Thank you, ma'am.
Mhm. Yeah, I believe that leaves us with 2. And I have Mr. Lewis's case. State would be asking, Mr. Lewis, you there?
I am.
Okay. The state's witness has not appeared yet. I would be asking,
Which case are you talking of?
you should only have Jamita Dixon left, right?
Oh,
Mansory. Did y'all make an
Mansory.
announcement on that one?
And hang on a second. Let me get these cases in front of me. All right.
The same announcement on both of them, Your Honor. Mansory and Mason.
Dixon. And Mansory.
Same announcement on both, Your Honor. Neither of the officers in those cases have appeared today. State would be asking for a reset.
Let me take these one at a time. So Mansory
Yes, sir.
officer has not appeared. We don't know why though.
No, Your Honor.
Is that the first time this case has been set?
No, sir. It was on 312, continued by the state.
Yeah.
Yep.
State request. We got unlawful removal of baggage. And we don't know in this case why the officer is not here today.
And to be completely honest, Your Honor, this would be, today is the second reset. It was on the
Okay.
12th and the officer did not appear. So,
this is the third time then the officer hasn't appeared?
yes, sir.
Okay. So I'm going to dismiss.
I didn't have that. Okay.
Okay.
I'm being honest, Creel. Give me credit.
Oh, okay. All right.
Okay,
I'm
gonna dismiss that one then today. On Idrissa Mansory. Let me write this down before so I don't forget it because I want to get that over there. Okay, and then what was the second case?
Jamita
Dixon.
Yes.
Okay, let me hang on just a second. Let me get to that.
So Your Honor, Mansory, he can go.
Dixon. Mansory, yeah, with that charge is being dismissed today.
Okay, thank you.
Okay, thank you. Let me find Dixon here.